Good evening and welcome to SEO's daily updates. Day 3 of the plea to recognize marriage equality for the queer community happened today. Senior advocates Abhishek Manu Singhvi, Raju Ramachandran and KV Vishwanathan completed their arguments for the petitioners today. Picking up from where he left off yesterday, Dr. Singhvi discussed the evolution of a traditional family or a marriage system from olden times to now. He said that there was no justification or no traditional gender roles in terms of husband and wife present today as compared to in the past. Moreover, he also spoke about how when we talk about the queer community and the restrictions imposed upon them, it would be unfair to have one set of laws that govern the heterosexual community and a completely different set of laws that govern the homosexual community. Going about with his plea to make the Special Marriage Act more inclusive towards queer marriages, Dr. Singhvi spoke about making sure that the court interprets the Special Marriage Act in such a way that the fundamental rights are read along with the provisions of the Act. What he meant is, or rather he explained, that parliamentary intent alone was not the criteria to interpret the Special Marriage Act. Rather, the Supreme Court has a duty to ensure that the law complies with the fundamental rights enshrined in the Constitution. These rights include the right to equality, the right to dignity, the right to marry, both of which come under the right to life, as well as the right to freely express their religion and their gender. Moving further, Dr. Singhvi and also later on Senior Advocate Raju Ramachandran spoke about how privacy is an integral part of an individual's fundamental rights. On the aspect of the Special Marriage Act, they denounced this provision which requires couples marrying under the Act to provide a public notice that they are getting married. The 30-day public notice that the Special Marriage Act entails allows members of the public to place their objections to a marriage before the requisite authorities. Mr. Ramachandran questioned the court, how can a person be asked to give notice to the public while exercising their fundamental rights? Fundamental rights are something that each person is inherently and intrinsically entitled to. Moving further with his arguments, Mr. Ramachandran also addressed the union's submissions and comments where they termed the queer community's petition for marriage equality to be urban elitism. Mr. Ramachandran highlighted that his clients, a lesbian couple, one of whom is from the Dalit community and another of whom is from the OBC community, and both of whom are from a rural background. He said that it's not just urban elitism. In previous hearings, Dr. Singhvi had also elaborated that it's not an urban phenomenon that there are people coming out of the closet. It is rather that there are also members of the homosexual and other queer communities existing in rural backgrounds who either do not have the publicity or who have not come out yet or who are just not being acknowledged so far. Moving on with his arguments, Mr. Ramachandran also highlighted an irony behind the 30-day notice period. He said that the 30-day notice period was borrowed verbatim from an older law or an older legislation back from the colonial era. This law was called Act for Better Preventing Clandestine Marriages, where the British government wanted to prevent certain marriages, and any Hindu who wanted to marry under this act was required to renounce their religion. This 30-day notice period was included to enable that. He said it was particularly ironic since the Special Marriage Act has no such requirement or no such or is rather intended for was originally intended as a secular legislation for interfaith couples where members would not have to renounce their own religions to marry the person of their choice. Next, Mr. KV Vishwanathan addressed the union's primary claim that homosexual marriages must not be recognized because homosexual couples cannot procreate or have children. Addressing the absurdity of this argument, Mr. Vishwanathan pointed out that no other personal law that governs marriage prevents any couple who are beyond reproducing, the age of reproductive capacity, or even couples who wish to be child free to be banned or restricted from getting married. This restriction is solely placed only on the homosexual marriages. He pointed out that procreation is not the pedestal or not the primary objective of marriage. Rather, it is an incidental part of marriage which couples may or may not choose to engage in. Finally, all three petitioners, all three senior advocates, when they presented their prayers before the court, did not want a new legislation, did not want the Supreme Court to make a new law or to even strike down the Special Marriage Act. They said that the Special Marriage Act is sufficiently accommodative, and all the Supreme Court has to do is to read the fundamental rights of the queer community into the Special Marriage Act. All other practical realities would follow once this has been done. That's all for today. Stay tuned on SC Observer for more detailed reports on today's hearings and on all the other days. For more information on the same-sex plea and other notable cases on the Supreme Court, please visit scobserver.in. Thank you.